Prominent British Columbia social activist Kari Simpson, who is a spokesperson for you if you believe, as most civil-minded Canadians do, that conventional morality creates and protects social harmony, Kari has written to Prime Minister Harper, asking him to provide the leadership his office demands in protecting all Canadians' freedom of expression and their right to a fair and impartial hearing in our courts. In her letter, she draws to the Prime Minister's attention, in what RoadKillRadio is calling Drive for Justice, some egregious violations of those very rights. In a defamation lawsuit that worked its way through the BC Supreme Court, the BC Court of Appeals, and finally to the Supreme Court of Canada, those rights were repeatedly violated with the knowledge and complicity of other judges and lawyers. Her questions to the Prime Minister include the information that a judge of the BC Supreme Court, who has admitted financially supporting her spouse while he was using the internet for, among other things, promoting hatred and contempt for Jews generally, and vilifying, defaming, and libeling several prominent Jewish businessmen. At the same time, this same judge presided over a defamation suit that involves a high-profile former lawyer, a member of the legal brethren, a former MLA and provincial cabinet minister, and also a member of the media, who has publicly stated that he does not want influential Judeo-Christians, as the plaintiff is, to hold public office. Now, if that judge also transfers property title from her spouse to herself so that he escapes payment of a court-awarded judgment after he was found to have defamed the Jewish businessmen, isn't that called fraudulent conveyance? And doesn't that vitiate the protection that is afforded to judges, which they have only as long as they are of good behavior, according to the Constitution Act? So question one is, don't the ethical standards of the Canadian Judicial Council require that a judge, when personally embroiled in such conflicts, must disqualify herself from a case that is similar in fact, that is, it's defamation involving religious bigotry? And question two, should the Chief Justice of the BC Supreme Court, also a member of the Canadian Judicial Council, preside over a legal matter involving one of his own judges? Question three, doesn't a party to a legal proceeding have the right to know what legal test they have to meet in court? And if the Supreme Court of Canada changes the legal test in mid-trial, as Chief Justice McLaughlin did in this case, isn't there an obligation to allow the parties to the trial to restate their case, incorporating the new standard? Question four, what gives justices of the High Court the right to repeat lies that defame an individual, and indeed to embellish them, as happened in this case? And question five, how can the Canadian Judicial Council be trusted to investigate its own activities? How can the legal brethren be trusted to sit in judgment of their own activities? But perhaps the most important question of all in Mrs. Simpson's letter to the Prime Minister is this: will he call for a parliamentary inquiry into this evidence of judicial corruption and mocking of the rule of law? When judicial independence is abused to protect those who violate judicial probity, there must be some venue of appeal and accountability beyond the courts themselves. That is the essence of the drive for justice. There is a famous precedent in Canadian law In 1927, the Supreme Court of Canada ruled that women were not persons in law. In 1929, 5 spunky women from Alberta appealed that ruling to the Privy Council at Westminster, which at that time had the authority to review Supreme Court decisions. Canadians lost that right of appeal in 1947, and it has never been replaced. The loss of that right, the right to appeal to a body that is accountable to the Constitution, was a serious deficiency in Prime Minister Trudeau's 1982 Constitution Act, and that deficiency still needs to be corrected today. Will the Prime Minister act to protect the integrity of the judicial system and to restore the confidence of the Canadian people in the administration of the law? Stay tuned.